interested in privacy and the public interest, and in research use of patient information in particular. I'm a senior lecturer at the law school, University of Sheffield, and there I'm Deputy Director of the Sheffield Institute for Biotechnology, Law and Ethics. Outside of the university, I am currently Chair of the Confidentiality Advisory Group for the Health Research Authority, and amongst other things I'm a member of Dame Fiona Caldicott's Information Governance Oversight Panel.
Mark, tell us about the importance of privacy protection in health research.
I think privacy protection is important because it's about respect for persons and about ensuring that individuals trust the individuals to whom they share information. So if information is being given to a researcher, then we want people to be confident that the researcher is only going to be using the data that they get in ways which are consistent with their individuals' expectations. And I think that's about protecting their privacy. Privacy isn't only about keeping stuff secret. Privacy is about ensuring that data is only used in ways that are consistent with an individual's reasonable expectations. So I think privacy protection in relation to research is about ensuring that data is used for research if that's the purpose for which it's been given, but it's about ensuring that it's only used in ways which the individual intended for it to be used, if it's been given directly for research purposes. If the data was originally given for other purposes, then privacy protection becomes even more important. So if we're collecting data during the course of delivering healthcare, for instance, a failure to respect privacy in relation to that individual's data not only threatens the relationship between the individual and the researcher, but it threatens the relationship between the individual and the healthcare professional. And so privacy is important there because undermining confidence in that relationship is actually undermining confidence in a relationship which is critical to an individual's care.
What are the main challenges and where do you think that we can find the best solutions?
One of the main challenges, I think, follows from what are increasingly fluid contexts in which data finds itself, and making clear to individuals how their data can and will be used in the future. So there are so many possibilities now when it comes to the uses of data. There are so many uses that we can't even anticipate right now at the time we're gathering information from people, but we might think are massively important, very valuable in years to come. How at this point in time, if now is when we're collecting the data, can we ensure that people are adequately informed about what those future uses might be? So if we want people to be confident that they know how their information is being used, if we want to use it in ways that they would want and think are appropriate, how do we overcome this problem of fluidity in context and ensure that uses are only, or the only uses which are made are those uses which people would recognise as appropriate?
Trust is obviously important and there's a lot of talk about it in the media at the minute, but what can be done to secure and maintain it?
For me, trust relates to what might be called a relied upon expectation. So I trust this chair now to take my weight, I expect it to. I rely upon it doing so when I sit down. If I'm giving information across to someone, I have certain expectations about what they're going to do with that information, and I rely upon those expectations when I give them that data. So it's similar to my last answer really, because I think in order to maintain trust, to protect it, to promote it, we have to ensure that people expect the uses which are then made of their data, so that there are no surprises. That's challenging, but unless we can succeed in that, I think we're going to struggle to maintain trust in the long run.
Tell us about the legal challenges of dealing with and protecting genetic data. Can the law cope?
I think there are many challenges associated with dealing with and protecting genetic data. I don't actually subscribe to genetic exceptionism, so I think many of the challenges are common to other types of health data. But genetic data does provide a useful and interesting case in point. It illustrates well a number of different challenges. Challenges associated with when data is identifiable, how one appropriately takes context into account as well as content. Challenges related to data relating to multiple persons. So law tends typically to view data, if it's personal data, as personal data about an individual, and genetic data gives the lie to that, and it is a good example of data that relates to more than one person. I don't think the law does cope with that particularly well. The other thing which I think genetic data challenges is access to information, the right to know, the right not to know, and questions around feedback of information. Because when one has gathered, say, a whole genome sequence, the fact one has it doesn't mean that one has analysed all of it. And the questions around, well, which bits of that sequence do we subject to analysis? When do we subject them to analysis? Who do we feed them back through, if we feed them back at all? To what extent does the patient have a say in whether or not they get this data? How do you ask the questions about whether they want the data without raising concerns about? These are all questions which I don't think we have a consistent consensus in relation to appropriate answers.
What kind of new data architecture do you envision that can enhance and improve existing uses of data?
I think there are opportunities in improved data architecture to improve both security and the ways in which individuals are consulted over the uses of their data. So in relation to security, I think there are opportunities to develop systems which allow individuals to access data, perform analysis using data, but never actually downloading the data. So increasingly it's becoming technologically possible to provide individuals access to systems that are more, if it was a library, there'd be more kind of the reading room which has books which you can access, you can read, but you can't take out, as opposed to the books which you check out and take home. Now, the more we can move towards a system which has closed access, where individuals can go in and use data in secure ways without actually downloading anything, without taking anything away, I think there are massive opportunities to improve security. With that comes increased opportunities to consult with individuals, because technology also should provide us with ways of communicating with people how their information is being used, and giving them opportunities to register their preferences in relation to that use. Now, if data is being used within closed systems, then it's easier to be able to, going back to the point we made earlier about fluid information contexts, it's easier to maintain control over who has access for what purposes, and then an individual's preferences in relation to that use can be more reliably actioned. So I think there are opportunities within new architectures to both improve security and improve the ways in which we can reliably respect individual preferences, because the systems will be set up in ways that allow for an individual's expressed preference in relation to the use of their data to be actioned by different parts of the system. It's interoperable in ways that allow for preferences to be cascaded through a system. And increased opportunities for consultation, communication and security, I think, are quite exciting possibilities for the near future.
What are the synergies between privacy and the public interest? And is there any discord between them in theory and practice?
For me, privacy and public interest are two sides of the same coin. What we are trying to do is set up a system that promotes and protects the conditions under which we can live together according to certain principles of respect for persons, principles of ensuring that each individual is, so far as possible, able to pursue their own individual conception of the good life. Okay, that's what we want. We want a peaceful, harmonious, civilized society. Those things are going to promote the conditions under which individuals can coexist under conditions of mutual respect. They are in the public interest. Protecting individuals' privacy is one of those things. So for me, protecting privacy is about both protecting an individual's interest in the norms of access and use of their data, but it's also about protecting the public interest in the conditions that are conducive to that kind of society. So I tend to resist a characterisation of privacy and public interest which puts them on a seesaw and says one must necessarily give way to the other. There are circumstances where different public interests, the public interest in privacy, the public interest in research, do come into tension and they need to be resolved. But for me they are resolved then through a trade-off which itself can be explained and justified. So I think we have to think about what the basic conditions are that we're trying to promote within society, what are the principles that we wish to live by, and respecting privacy is one of them, together with respecting other interests, including the interests in health research and the protection and promotion of individuals' health and health care and treatments. So privacy, public interest, to me, the different ways of approaching a common goal, which is about living within a civil society under a certain set of conditions that we agree are mutually acceptable, that we have reason to accept.
What are your thoughts on the General Data Protection Regulation?
I'm sympathetic to what it's trying to achieve. I recognise that the Data Protection Directive hasn't achieved the level of harmony across Europe that it was hoped and intended to. I'm certainly definitely sympathetic to the idea that we need a data protection regime that is going to protect individuals' fundamental rights and freedoms, especially privacy. So a lot of what it's trying to do, I'm entirely supportive of. There are certain aspects of the current proposals which cause me some concern, particularly those around research, use of health information, and the suggestion, certainly in at least one of the multiple versions that are currently being, soon to be discussed, with a view to reconciling and having a final version of the text. But at least one of the versions, the Parliament's text, seems to suggest that research use of health data needs to be on the basis of explicit consent. And it's not practical in each and every case. And it does seem to recognise that when it says that member states may provide for exceptions to this. But in cases of high public interest, I have a concern with the use of the term high public interest, because my own conceptualisation and understanding of public interest is that something's either in the public interest or it's not. So exactly what is added by the use of the term high, I don't really understand. And the suggestion that if it's not being done with consent and it is in the high public interest, then it needs to be done in ways that are pseudonymised. And I don't really understand what is being meant by the use of the term pseudonymised here, because if one just looks at the text and one sees that they mean the data which may identify an individual as being held separately from the data which is then subject to analysis, I just don't see how that can work in relation to a lot of data, a lot of research which relies upon data, and the analysis of data that is potentially identifiable. So data in relation to where an individual lives and how close where they live is to the power line or whatever it happens to be. But some research needs identifiable data, it relies upon identifiable data, and some research can't proceed on the basis of individual explicit consent. And I don't see sufficient recognition of the public and private interest in research taking place using identifiable data without explicit patient consent in some circumstances. Of course, consent is what should be sought where it can be. Of course, one should de-identify and use anonymised or pseudonymised data where one can. But there needs also to be recognition of the fact that sometimes you need to use data which is potentially identifiable. You need to use it in circumstances where you can't get individual consent, and to prevent research of that kind going ahead, I think would be wrong. And the risk that is present within at least one of the drafts of the current regulation is concerning for that reason.
What's next for privacy and public interest in health research?
I think the massive potential that lies within information technology, information processing, the opportunities which are going to exist to do things that we can't even imagine today are really, really exciting. But it also makes it really, really hard to know how the principles which we're currently working with, the ones which we are reasonably familiar with interpretation and application of, how they are to be understood to apply in the future. So if we want to protect people from the misuse of information in the future, what will that mean? I think it's challenging to engage with people about this through a consent model, for the reasons I gave earlier. And so I think we do need to have principles that will apply when there is consent and when there isn't, so that there are adequate safeguards there against improper use. But thinking through all of the future scenarios, all the future possibilities, and being confident that the principles and interpretation and the processes that we currently apply are fit for purpose, I think it's really hard to know that we're ready.
Mm-hmm.
I think it's really hard to know be confident that we're ready for what's coming when we don't really know what that is. So I think there is a lot of work to be done around the principles and finding ways in which we can iterate and interpret the principles in ways that will maintain public confidence in a changing landscape. So how are we going to move? How are we going to move as regulators, as lawyers? How are we going to move the regulatory landscape to keep pace with the changes that are taking place outside of the regulatory landscape in ways that deserve public confidence? That the dynamic of what's happening now within the space is exciting, but it's also massively challenging from a regulatory perspective.